Just a few moments. Thank you all for joining PCR SBDC today. And good morning, everyone. Thank you all for joining PCR SBDC today as we go through our second in a series with the U.S. Patent and Trademark Office. We are so excited to have them today. Today's topic is patent basics. Last week, you guys got a 101 of patents and trademarks and copyrights. And today we're doing a deeper dive for those inventors. That are looking to do something special. And so we're so excited to have you guys on today. And we're going to be doing introductions. For those on the call, if you guys would please keep yourselves mute. And we are happy to answer chats in the, or answer your questions in the chat box. And our experts are ready, willing, and able to answer your questions today. So we're excited about that. So please put your questions into the chat. We will be recording this presentation, and so we'll be able to provide this presentation to you as well as a PDF version in a couple of days. So for those that are joining today. So let's start. I just wanted to announce tomorrow is actually SBDC Day. That is a time in our country when the clients of the SBDC and those that have benefited from the SBDC are able to share good works. We might have a video to show you of a couple of our clients that we have been able to support and help during the pandemic, particularly in 2020. I know Jeanette Bolden, thank you, Jeanette, for doing that for us. I see you there, one of our clients. And so we appreciate all of you on the call. We thank you all for participating with the SBDC. Our role is here to help businesses start, grow, survive, and succeed. So, but today is about innovation. So that's what patents are about. It's about new stuff. And so we're hoping that you guys are able to take these ideas and concepts and apply them to your business in the future. So SBDC, one of 1,000 centers around the country. Ours is one of 9 in the LA area. And we're a proud partner with the SBA as well as the state of California in the Go Biz program. We provide business consulting, training, resources for small businesses, and mostly in LA County, even though during the pandemic, we got people from everywhere, and we tried to help whenever we could. But we provide workshops in legal areas like today, business planning, management, and marketing, certification if you need that. So we have a wide variety of areas that we can assist you with. And if we can't assist you in an area, then we will make sure that we get you to an advisor, even in another center that can assist you. All of this is at no cost and no catch to you. So I'm so glad that you guys are on the call today, because that means that you are using your taxpayer dollars well and coming to a great presentation. So I'm Colette Moore. I'm the director of PCR SBDC. And I was a previous business owner for 8 years. I actually had a staffing company, and I was a client of PCR SBDC, sometimes a good client, sometimes a bad client. So my goal is to help you all to become good clients and therefore truly long-term and successful businesses. So and then today we actually have Steve Cozio, and we are so excited. Steve is the Assistant Regional Director of the Western Regional U.S. Patent and Trademark Office. He joined the USPTO in 2007 as a patent examiner. has managed teams of examiners in the computer graphics and digital imaging fields. And some people think that only patents can be on products, but there are a whole bunch of other areas as well. So prior to his move to the West Coast, he worked in the Rocky Mountain Regional Office, where he led the design and implementation of various intellectual property outreach and education programs. He's also focused on the development and patent-specific programs within the USPTO, including the Post-Grant Outcomes Program, AIA First Inventor to File implementation. And he's also been involved with patent operations, cost, and fee modeling. He received his Bachelor of Science degree in Electrical Engineering from Bradley University in Peoria University. And so I'm excited to share today. Steve Koziel, before I start, thank you all for letting us see you on screen. So we appreciate having an opportunity to see you guys. I just ask that if you get up and start moving around, if you would take your screen off your visual until you come back and are seated, because it makes me dizzy with a lot of moving around. So you guys, if we're happy to see you, just if you're in a seated position, that's great, but just turn off when you, and then come back. All right, so with that, I am happy to introduce the USPTO, Steve Koziel, to present our topic for today, which is patents, patent basics. Welcome, Steve.
Great, wonderful, and thank you for that introduction, Colette. Really appreciate that, and really appreciate getting the opportunity to talk to your clients about this this topic today. Hopefully, you all can see my screen. I'm just going to jump ahead one slide here just to make sure that we're all moving. So, okay, great, and so. The topic today is patent basics, and I think a warning might be in order up front. You know, patents can get very complex very quickly. So I'm going to be sharing with you a range of information here today, everything from what patents are, what they cover, what they don't cover, so you have a better sense of whether or not they're really something that you should pursue, or at least be able to know when it may be in your interest to pursue them, all the way through some of the nuts and bolts of how to actually go about filing for a patent application, including what legal resources may be available for you at low or no cost locally, and how the SBDCs can help connect you with them. And so, you know, hopefully there's a lot of material here today. Don't expect everyone to kind of become an expert at it by the end of our conversation. But like Colette said, she's going to share a copy of these slides for you, so they are a resource for you going forward, something to keep in your back pocket that you can take a look at when you need that information, or when you need to know who to ask. So before we jump in, I believe Briajani has a poll for us that she's going to put up on the Zoom. So we'll just do a quick temperature check of the room to see what you all know about patents, and how you would kind of describe yourself. So if you see that pop up on your screen, go ahead and respond to that, and we'll take the temperature of the room. Okay, drum roll, please. So it looks like the results are in, and the almost 60% of the group here today would describe themselves as a novice to the field here, and the you know, so the overwhelming majority of folks are kind of new to the patent system. So that helps me focus my remarks, and hopefully will at least make you a little bit more savvy in navigating the IP and patent system this morning. And like Colette said, we're going to be monitoring the chat box here in the Zoom too. If you do have questions, feel free to add them to the chat. I'll try to leave some time at the end of the presentation this morning for Q&A to make sure that we can get your questions answered. So with that, I've got like I said, a whole bunch of material here, and I may move fairly quickly through it just to make sure that we have a chance to cover as much as we can cover today, and look forward to hearing your questions as well as we go through. So. Just take a look here at what we're looking to cover. I'll give a bit of a background on the history of intellectual property and the patent system, just kind of how we got to where we are today. I'll spend the bulk of the time though talking about what actually is a patent, what it covers, what different types of patents are out there, and what it's like to actually go through the process of applying for and obtaining a patent. I think it surprises a lot of people to know that it's time consuming. It is often a multi-year effort to go from preparing a patent, filing it, working with your attorney and your patent examiner to actually get it allowed. So, a trademark application is something you could turn around in a few months in most instances, but a patent application, it's really a long-term business asset that it takes time to get right. So we'll talk a little bit about that patent application journey and what the USPTO can and can't do to help. And then for those areas where we're not able to help, we'll talk about pro bono legal resources that may be available to you all, and how folks like the SBDCs and the Patent and Trademark Resource Centers can help you take the next steps to really translate your ideas into a tangible asset that you and your business owns. So that's what we're looking to cover today. Let me just jump back. So where does this all come from? Patents in particular are one of the few areas of U.S. law that really draw directly from the Constitution. If you're curious, it goes all the way back to Article 1 of the U.S. Constitution, where the basis for the modern intellectual property system is founded, including patents and all of copyright law. As well. So it certainly has evolved over time, but it is, patents and copyrights are fundamental to the, go back as far as the founding of the country. And when we talk about patents in particular, some people think that a patent gives you a monopoly on an idea that you have. And we'd like to push people away from that thought. Maybe you've watched Shark Tank and you hear people ask the question, oh, do you have that's a great idea, but do you have a patent on it? And why do they ask that, right? Why does it matter that you have a patent on something, particularly if you're in that Shark Tank type environment where maybe you're looking to get funding, right? Maybe you're looking to talk with someone about manufacturing because you've got a prototype in your garage, and how do you go from prototype to your first 1,000 to 10,000 to 100,000 units of what you're trying to sell? How do you protect yourself in that process? How do you prevent someone from ripping you off or copying your design or copying the functionality or the look and feel of your product or your software or an application for a mobile phone that you're developing? And that's where the patent comes in. And rather than giving you a monopoly on your idea, the patent gives you the right to prevent others from making, using, selling, or importing what you claim in your invention. And I'm going to come back to that idea of what you claim in a few slides. So it's the right to prevent others from making, using, selling, offering for sale. So keep that in mind. Keep in mind that it is not everlasting. A patent expires after 20 years from the date that you file the application. So when I say expires, I mean the idea in the patent goes back into the public domain and can be used by anyone. So a patent gives you a limited term to commercialize and capitalize on your idea that you claim. And all intellectual property that we're going to talk about today, including patents, are territorial, right? A US patent only protects you within the United States, right? So if you're going to be going overseas, if you're going to be selling your product, your invention in markets outside of the US and deriving a significant source of revenue from outside the US, you need to be thinking about protection in each of those countries individually, right? There's no such thing as a worldwide patent. So if you're gonna be doing substantial business in countries outside the US, including even manufacturing outside the US, you do want to think about localized intellectual property protection there. So a quick question, I'm just pause there, see a question coming through in the chat on that 20-year term for the patent. 20 years from the date, from the effective filing date of the patent, as opposed to the date that it's granted. So that was a change in law that happened a few years back. But for the current law that we're working under, it's 20 years from the date of filing your patent application. So just to clarify that point, that was different a few years back, but there were a few substantial changes in the law that altered that. And so when we talk about patents, really there were three different types of patents. And this is something that I think escapes a lot of people. The overwhelming majority of patents that we see, we would call utility patents, right? These are patents for inventions, the things that you would see on Shark Tank, 99% of the time, those would be protected by utility patents. However, there are two other types of patents, and I'm just going to spend a few seconds on each. So just to make you aware of, design patents protect the physical shape of an object, so how an object looks rather than what it does can be protected by a design patent. So utility patents protect the kind of the what it is and what it does, the function, if you will. And a design patent protects just the ornamental look and feel, the physical shape of a product. So for example, every time there's a new iteration of a car that comes out for, the shape of the car, the exact contours of the fender, the bumper, the slope line of the roof, all of that is protected, and it's protected through design patents because those are not functional elements. They're aesthetic elements related to the look and feel. And I spend time on this because it's easy for people, particularly those designers and engineers, to overlook the importance of design patents. You may remember a few years back, there was a long-going case between Apple and Samsung, a long patent dispute between Apple and Samsung about various parts of some of the Samsung phones versus the iPhone. And at the heart of that dispute were design patents. I mean, there were other patents, but there were design patents. If you remember part of that case, it was about the look and feel of Apple's iPhone, right down to the way that the corners of the phone were curved compared to the curvature on the corresponding Samsung phone. And so that is something like the ornamental design of a physical product. The ultimate decision was in the billions of dollars, just related to the look and feel of a product like that. So if you rely on design or the ornamental look and feel of your product for, you know, brand awareness or for distinctiveness, of your product that you're looking to sell, do keep in mind that design patents can play a crucial role in covering that which is unique to your product. And so that's all I'll say on design patents. And last but not least, plant patents are out there as well. So they protect basically any plant that isn't naturally grown. So a plant like a new variety of rose that you may design, a new petal design on a rose, or a new variety of tomato, let's say, that's particularly drought resistant. There has to be that innovative step that you provide, rather than something that you just discover in nature. You have to do something to actually alter that. So with that, these are not mutually exclusive. Just responding to a question I see here in the chat, you can have a product covered both by a design patent and a utility patent, right? If you think about to go back to the mobile phone example, there are probably, dozens of utility patents on any given mobile phone. Right, everything from the composition of the glass to the battery management system to the all of the processors in the phone and how they operate together, along with the visual distinctive features, right? The way that the corners angle just so, or the height to width ratios, and all of that. So a single product can be covered by multiple utility patents as well as multiple design patents. And so with that, I'll just introduce why we're talking to you today. So as Colette mentioned, I work for the United States Patent and Trademark Office. We are the only agency in the United States that's authorized to receive, examine, and grant patent applications as well as trademark applications. So that is our role, and we also have this role of providing education and outreach to the public as well as part of our charge. So talk a little bit now about patents in the overall business environment. What's the business case for investing in patents, and what can they help you do? So at just a high level, we talked about the exclusivity factor early on, right? Patents prevent your competitors from copying your ideas. And, that really allows you to, the certainty that your invention is, if it's successful, you're going to be able to recoup the cost that you invested in the research and development, recoup the cost that you invested in marketing that product and building out your initial customers, if that product is successful, because nobody is going to be able to copy your exact idea. What if you're within the context of working for a larger company, often patents are a way to advance your career as well, right? To kind of build your resume, or to help you be successful at launching other ventures as well, to have that experience of going through the patent system successfully and having an asset that you're able to monetize at the end of it. And we've got some hard numbers to back that up as well. The citation for this is at the very end of the slides, but we estimate that there's over 45 million jobs in the U.S. That derive from what we call intellectual property intensive industries, right? So the bottom line is that this is IP and patents in particular are tremendously supportive of job creation in the U.S. And it's not just job creation, it's high quality jobs in the US, right? Those industries that are intellectual property intensive and patent intensive in particular are positively correlated with higher pay for the average worker in those fields. So so patents and intellectual property are a way, not only to create jobs for through your businesses, but really drive high quality jobs into the U.S. economy as well. So with that, I want to do a little deeper dive here into the patent itself, and this is kind of where we get specific, and Colette may recognize this, but we have here an example of the front page of a United States patent. And so this is the part where it's probably not that interesting at this point, but more for your reference later on. This is part of all of the information that goes onto a patent, right? Everything from an abstract, just a brief one paragraph description of the invention, so you see some drawings here at the bottom, a little tough to read on the screen. I apologize for that, but there's going to be drawings associated with just about every patent application that you see, that really walks people through various diagrams, flow charts, and views of your invention. As well as what I'll get to a little bit later on, something called claims, that really define the boundaries of your invention. Because think about what we're talking about here. An invention, is something that exists in your head. Maybe you turn it into a prototype, a physical object, or maybe it's software. You turn it into an app that you run on your phone, or maybe it's a method. It's a series of steps that you conduct, or maybe it's a chemical composition. All of those things have to be translated into a narrative description. And that's what the patent is, right? The patent document itself is a narrative description of a physical product and a series of method steps, a chemical composition, and where that idea actually becomes a legally protectable document through a patent is what we call the patent claims. So I want you to keep that in mind as we go through the rest of this conversation, the importance of the patent claim and why it may be, and in fact, in most cases, is beneficial to work with a patent attorney to help you prepare not only the patent application, but the claims themselves. And I'll talk a little bit more about how we might go about doing that. So why am I spending so much time talking about claims? Well, here's just a very, very simple example of a chair. And if this, let's just say that nobody has ever created a chair quite like this before, and this is your invention. So how do you go about protecting it through the claims? And so for an example like this, this is what a claim would look like. What's important about this chair that you want to protect? Well, you may introduce the seat. You may introduce the back that's attached to the seat, some supporting arms of some type, and a base that's attached to the seat. So it's language like that that is actually used to protect the invention that you have. Um, and the claim, the way to think about a claim is, if when you think about real estate and real property, right, there are distinctive boundaries that you can go to your county assessor's office and you can see, okay, where exactly does this plot of land end and this plot of land begin, or where does your house end and somebody else's house begin, and people would put a fence up or something like that. The claims are the patent equivalent of the fence that you put around your invention, right? So if the fence protects your property, the patent claims are the legal fence that protects your invention. So think about that for a minute. If you claim too much, if your chair was just a seat and two arms, right? Well, just about every chair in existence is going to be able to say, well, I've got a seat and two arms, so that's not going to be a very good claim, because you're extending your fence onto other people's properties, right? The equivalent of other people's properties, right? So, oh, okay, you might say, well, then I just want to claim exactly what I came up with. Well, it's possible to go way too narrow and only claim just a tiny, tiny fraction of what you really invented, right? So a patent claim has a tension, inherent tension at the heart of it, where you want to claim as much as you're entitled to, right? You think about, you want your backyard to be as big as possible without encroaching on your neighbor's backyard, or in the patent sense, your competitors' already claimed inventions, right? And that is a delicate balance. Claim too narrow and the resulting patent is not going to be valuable to you because you've claimed just a small corner of the backyard, that you might have been entitled to. Claim too much, and you're likely going to run headfirst into a number of lawsuits from your competitors saying that, wait a minute, that's mine. You're claiming my part of my backyard. So that is a very delicate balance that is at the heart of every patent document. And the reality is, most people who are new, and I'm assuming that's a lot of the folks on this call, most people that are new to this system don't really have the expertise to effectively, navigate that balance. And that's why this reason in particular is why we strongly encourage you to work, again, with the patent attorney on preparing your application. And in particular, it's to get that balance right in the claims. Because the last thing, if you take away one thing from this talk, is you can spend a lot of money on a patent application, on going back and forth with the patent office, only to have the resulting patent not be all that valuable to you if you don't get the balance right in your claims. So, that's why we want you to kind of go into this with eyes open, knowing that, patents can be, tremendously important to your business, right? We talked about between Apple and Samsung, there were billions of dollars at stake just over the look and feel of a phone. I don't know if any of you have $1 billion idea. I hope you do, and I hope you're able to protect it. But even if we're talking, tens or hundreds of thousands of dollars eventually at stake, or hopefully more than that at some point, the quality of the patent that you get issued is really going to be dispositive in that in the future. So we want you to take the time to get it right. So that's why we're spending so much time on it, and that's why we kind of want you to be aware of that. And I usually pause here and say if you're like me and you're often flipping channels late at night, you'll see certain commercials for maybe that little guy with the wheel, those invention help or those invention submission corporations that you do sometimes see. We encourage people to kind of take a buyer beware approach to some of those. They are often very good at extracting money and not necessarily giving you something valuable at the end of that process. So that's why we encourage you to, again, work with a registered and licensed patent attorney rather than with an invention submission corporation or someone that you see through a commercial or other promotional center, and that's where if you're not sure, folks at the SBDC or at our office are able to kind of help you navigate some of those decisions. So I'll come back and at the very end talk about some of the resources and how you can get connected with a patent attorney in your region. So we'll just put a pin in that idea for right now,
And
and
Steve,
talk a little bit more.
I wanted to share that we will go back and answer the questions. So people do have comments in. So if there are any that you missed, we'll go back and make sure that we pick up on those. So guys,
Sure.
hold on. Okay.
And I appreciate that. Yeah, and I do apologize if I'm missing folks' questions as they come through the chat, but I know
No problem.
Colette and her team are diligently tracking what's coming through. So we will get to you if we haven't already. Okay. So stepping back a little bit, it's worth talking about this idea of who is the inventor. And you remember, let me just go back to this. So our application that we showed as an example, you see there's 3 inventors listed here. I happen to like the second inventor here, but there's 3 inventors listed on the face of this patent. And that's fairly common. Anyone who contributes to the invention is considered an inventor. Right, so to go to our chair example, say you're working with a team of designers and one person was responsible for the back of the chair, and then there was another team that designed the base of the chair, and a third team that was working on the arms. It's probably overkill, but all of the people that contributed are entitled to be listed as inventors on the application. And in fact, you are required to list everyone who directly contributed to the invention when you actually file the patent application. And that's something that your attorney is going to be, asking you and working with you on. And we could spend an entire course on, well, how much do they actually have to contribute in order to be listed? But for the purposes of this course, just keep in mind, if they include something that makes you say, oh yeah, we've got to incorporate that into the product, then they are, in the eyes of the law, an inventor and are required to be listed on the patent application. Okay, so let's just walk through here. We've got it kind of broken out into 4 pieces. How do you actually go from that idea to deciding if it's something you should file a patent for, and actually putting together an application and working with an attorney to really go from idea a patent that gets issued. So I I alluded to this before, but just to get a little bit more specific now. Um, it's kind of easy. There's only four things that are eligible for patent protection, right? And the good news is that they're incredibly broad categories that can capture almost anything that you may think of, right? So any process, right? And I'm talking down to a way of manufacturing, a series of steps that you follow as part of an internal business process. Any process, anything that you may be able to capture in a flow chart, a concrete series of steps from beginning to end, is something that can be eligible for patent protection. Of course, any machine, and the language that I'm using here is just the language that's directly drawn from the statute. So it may seem a little archaic to be talking about things like machines or compositions of matter, but that's the direct statutory basis for what is eligible for invention in the US. So any physical product essentially falls into that machine, whether it's a microchip or exercise equipment. It kind of falls into that category. Manufacture as well. So anything that you're assembling, or not just a microchip, but say the entire printed circuit board as well could fall under the manufacture category. As well as this compositions of matter, so that a lot of pharmaceutical drugs you read about are under patent protection, or they get a lot cheaper when they go off patent protection. So that's where any new and original composition of matter comes into play. As well. So the idea is those are incredibly broad categories, and just about anything that you can think of falls into those categories. So now that you've got something that you may be interested in protecting, and we've got an example here, just a simple, kind of a string trimmer idea here. How do you know if you're going to be successful at getting a patent, right? What's the legal requirement here? You've got an idea. Do you have to be the only person in history that's ever thought of that idea? Do how different does your idea have to be before you can be confident that you're likely to get a patent on it? And the legal standard here to answer that question is this idea of, is your invention novel and non-obvious? Right? So those are legal terms, and I'll just break them down a little bit. Novel refers to, is your invention different from anything that's come before it and when I say your invention, I'm talking here about exactly how you're claiming, remember our claims, exactly how you're claiming your invention. Is that different from anything that has come before it? And you see this idea, well, what do you mean what's come before it? Hold that thought, and I'll come back to that in another slide. And the reality is, most inventions that we see come through the patent office pass this novelty test, right? There is something that's different about them from what's come before. Maybe you changed the shape of the guard on this trimmer, or maybe the way that the rotation angle of the motor is slightly different from what's come before. So it's likely that if you have if you have an invention, you have a good chance of passing this novelty test, right? And there's something different about it from what's come before. So the question then is, well, how different? How different does it have to be compared to what's come before for you to get to be confident that you'll be able to get a patent. And that's the challenge. That's where this idea of non-obvious comes in. What do you mean obvious? Obvious to whom, right? It's a subjective standard, but it's one that has a historical basis in U.S. case law. And basically, that's where, when I said before that it can often take 2 or so years on average to get your patent issued, that's where a lot of the 2 years are spent. It's you and your patent examiner kind of going back and forth on whether or not your invention would have been obvious to someone in that field. And that's tricky, right? And that is, again, a great use of a patent attorney is to help you.
All right, Steve should be back in just a second, guys. I'm not sure um, where he went. So if you would just hold for just a moment and our presenter will be coming back. And if he needs help, I can pull up. All right, Steve, you are back. And I see our presenter. You guys just hold on. And thank you for your comments and your notes in there as well. So appreciate it. And we will get to your questions in just a moment. And Steve, let me know if you can hear me, if you need for me to pull up the presentation. And I'm happy to do that.
Steve, try to unmute yourself now once I did the perfect.
Okay, I think that did the trick. I apologize for that, everyone. I think, our, just a few months ago, we were completely banned from using Zoom. So we're slowly getting acclimated to this world, and sometimes we do have some hiccups there. So
And Steve,
hopefully
I'm
you all
happy
can.
if it happens again, I'm happy to switch over and I can drive. So, all right.
Sure. So appreciate your patience there. So hopefully you can see my screen again, and we will power through. So I mentioned this idea of obviousness, and again, you have to be able to demonstrate that your invention is different enough from what's come before it. And the idea of what's come before it is captured in the concept that we call prior art. Right, that's just a legal term that refers to any printed publication, right? If it could be a patent, it could be an article, it can be an actual product itself that you see on store shelves, and anything that's publicly accessible, that has come before the filing date of your patent application. So when an examiner says, okay, I don't think your idea is is non-obvious, they prove it using prior art, right? It's not just an opinion that the examiner has. The examiner has to make a case showing actual publicly available either products, printed publications, or other patents that show every single part of your claim, where it's been done before, and why it would not have been obvious to do that, right? So one of the things we encourage people to do, and as a way to save time and money, is to do your own search even before you think about filing a patent application, right? One of the first things you can do when you have an idea, when you think, hey, this is something that maybe I could patent, is to go out and see just how much of it has been done before, right? So do a search in some of the patent databases out there to see if someone has described it before. Do a search in some of the trade magazines that are particular to your industry to see if a similar product has recently been launched at a trade show or the like, and really have a good sense of how much of your idea has been publicly disclosed before. And that's going to be a key determinant in whether or not you should go through with the patent process. So do keep that in mind. That's the first kind of reality check in the entire process is. And I know this is hard for people to hear. They've got an idea, they think it's amazing, they want to go through with it. And if somebody else has done 95% of that, it's really going to be tough for you to go forward and get a patent. Or if the patent you get is only on 5%, right? Think of that as just being a very small corner of that backyard that you're able to fence. Is that really going to be worth your time and your effort, right? So that's kind of it within that step one, right? That's the reality check. There is, has this really been done before? And that's something that you can do yourself. You don't need an attorney to do that for you. You can do that yourself. And we, at the USPTO, we offer a number of classes on free, of course, all free of charge classes for how to do a search for prior art, how to really dig in and see if your idea has been done before. So if you're looking and you're thinking about, okay, I may have something here and I want to take the next step, we'd encourage you to sign up for an upcoming class on patent searching that we have. Okay. So step two, and this is where people can unintentionally trip up here a little bit. So I want to spend a little bit of time talking about, okay, you've got an idea, you've done your search, you think you may have something that really can be protected here. So how do you go about talking to others, or do you talk to others about developing your idea and maybe even getting a patent on it? So one note of caution here is that you can do a lot of damage to your company and to your ability to ever protect your invention if you start publicly disclosing your invention before you talk to an attorney or before you file at least a patent application on it, right? And what do I mean by public disclosure? I mean anything that you put out into the world that is publicly accessible. So a lot of times we see that in the form of, particularly with new companies, a type of crowdsourcing campaign, right? Maybe you go on to Kickstarter or equivalent, and you put your product out there and you start offering it for sale through crowdfunding, or you talk with maybe you have a blog that you're using to track the development of your idea, or a YouTube channel that you're using to track the development of your company. If you disclose your invention on one of those publicly accessible mediums, or a trade show, even if you go to a trade show, I don't know who's going to trade shows these days, but if you go to a trade show and actually offer your product for sale or make it publicly available, that starts a 1-year clock from the date that you first make that invention of yours publicly available. You then have 1 year to file a patent application on that idea, right? If you don't file the patent application within 1 year of that public disclosure, then you lose out. In the United States, you are not able to protect that idea through a patent in the United States. That is just the way that the law is written. So what we encourage people to do is don't be afraid of public disclosure, or don't be unnecessarily cautious around public disclosure, but be deliberate, right? If you're going to disclose something publicly at a trade show, at a, through a crowdfunding campaign, that's fine. Just know that the clock is ticking. And when in doubt, you can file a quick, what we call a provisional patent application that I'll talk about in a few slides, immediately before that public disclosure, which protects your ability and kind of gets you that patent pending status, right? So, at the end of the day, anything that you say to an attorney, right, there's going to be that attorney-client privilege there, so that's not public disclosure. But anything else that you make available to the public can really come back to bite you if you're not careful. So do be cautious around that idea. Okay. So let me talk a little bit then about what goes into the patent itself. And we kind of talked about this before, but think about the patent is taking your idea, translating it into words, right? Whether it's a physical product or chemical composition, translate that into words, and those words should be detailed enough that they're really an instruction manual for how to make and use your invention, right? That's at the end of the day, that's what the description of a patent is that an instruction manual that tells, you're telling the world how you came up with your invention. And again, in exchange for telling us, what you did, you get that 20 years of exclusivity, right? That 20 years of protection. So that's kind of the balance at the heart of the patent system. You've got to tell the world what you did so they can learn from it. But in exchange, you get that exclusivity, that 20-year period where no one else is able to copy your idea. And again, U.S. patent, remember, just protects you within the U.S., right? So if you want somebody, if you're concerned about China, if you're concerned about getting ripped off in another country, you need to consider the equivalent protection, the equivalent patent protection in those countries, as well. So I just condensed a few slides there, and again, you'll have all of these slides to peruse at your convenience after the fact. So the kind of the final step in that process that I'll talk about here is going through the actual filing of your application. And this is the first step in the process where we do need to talk about fees. And with that, I put up this chart just so you get a sense of how much it costs to actually file a utility patent application at the U.S. Patent and Trademark Office. And the first thing you'll notice is that there are 3 tiers of fees in our structure. And, if all of you are new to the patent system and you're part of you're an independent inventor or a small company, it's overwhelmingly likely that you qualify for this micro entity tier. And if you do the math, I think it's about a 75% discount from this large entity tier. So basically, large entities, these are your Googles, your Apples, we don't want people that are just getting into the system to have to pay the same fees that the larger players have to pay. So we have fee discounts throughout the filing of your patent application. So the initial cost, if you're a micro entity, is going to come out to about $455 to file that application with the U.S. Patent and Trademark Office. Now, attorney fees are a different matter, and we'll talk a little bit about that. But not to shock anyone, but just to be real, working with the patent attorney, unsubsidized, for a single patent application is likely going to run between $15,000 to $20,000 just in attorney fees to prepare, file, and prosecute a single patent application. So you compare what the government charges under $500 to what it takes for an attorney to work with you to prosecute. That's an order of magnitude difference, and that's why we end this talk with the description of the free legal resources that are available to you that can connect you with a patent attorney at no cost or extremely low cost to help you through that process. Hopefully, too many people didn't jump off the call when they heard that sticker shock. But rest assured, there are resources available that will work with you. Because again, remember, if there's one thing you take away, most people really need an attorney. They need a registered licensed patent attorney if they want to get a patent that's worthwhile. And again, too, not everybody has, and not all small businesses have the $15,000 to $20,000 to realistically make that happen. So there are resources out there. So we don't want you to go it alone. We want you to work with people that are going to be able to help you out. So this just kind of shows kind of the high level view of what it's like after you've actually filed your patent application, and maybe this is a little cheesier than I thought it was when I first looked at it, but you kind of have a few reasons that it takes close to 2 years from this initial point to the time you actually get your patent. And all this shows is that there's a lot of back and forth between you and your attorney and the patent examiner who's working on your case. And that really goes back to, remember we talked about that obviousness, what is or isn't obvious in your invention. That's where the bulk of that time gets spent. And that's just a quick illustration there. And that's really what the patent examiner does is, they have a dual obligation. Right? They are there to protect the public interest by making sure that patents aren't overly broad when we allow them. But by overly broad, I mean that we don't give someone, remember going back to our fence analogy, we don't let someone put their fence where other people's fences are already staked out. But at the same time, they're there to make sure that you get good, appropriate coverage for your invention as well. That's going to be useful for you. So that's really the role of our agency, and specifically the role of the patent examiner. Is to strike that balance. And just to kind of go through these a little quickly, but just to get specific about it, I was looking for this one here. What does that mean? That means rejection. And rejection is not as negative as it sounds. 84% of initial patent applications receive what we call a notice of rejection at first, right? And that is normal, right? That does not mean that 84% of patents don't get eventually issued. It means that there is probably, more likely than not, there's going to be something about your application that the examiner objects to, or that the examiner says, wait a minute, you need to fix this, or I think you're putting your fence over somebody else's area here. And that's fine. That's part of the healthy back and forth between you and your attorney and the patent examiner to make sure that, again, at the end of the day, your fence is where you need it to be. It's not on somebody else's property, and it's not so small that it's not valuable to you. So don't be surprised when your first response from the patent office is that notice of rejection, right? It's not the end of a conversation. It's the start of a conversation with you and your patent examiner that goes on. And the good news is that just in our last fiscal year, for which we have numbers, it's almost 60% of those filed patent applications do get finally approved. You know, that 84 turns into almost 60% by the end of the day. So you've got a good chance of approval ultimately. But there are going to be some rejections along the way, and you just have to navigate that. And what's an interview? Well, all I'll say here is that, you know, your examiner is a person, right? And it's often easier to deal with people over the phone or through video conference than it is in writing. And you have the ability to do that with your examiner. If you feel that your examiner is not understanding your invention or doesn't really appreciate what you're trying to protect, you have the ability to call them up with your attorney, to call them up and sit down for a half-hour conversation and say, look, here's what I think my invention is, and here's where I think your rejection is wrong. And a lot of times, you know, as you see by the chart here, you're more successful when you have that phone conversation or that video conversation with the examiner than you are just going back and forth and writing. So keep that in your back pocket when you do get to the point of filing and actually working with your examiner. You always have the right to call them up and to talk about your invention kind of over the phone or face to face. And it makes a difference, right? It really makes a difference in helping the examiner understand where you're coming from and getting you the patent that you need. So I mentioned the overall time frame of about 2 years, give or take. This is just kind of breaking it down if you're interested to what that time looks like. Not gonna spend a lot of time here, but this just shows kind of the various stages of what we call, I've used the term before, patent prosecution. This is actually what it looks like, and where we typically spend the time for your application. And hopefully at the end of all of that, you've gone through, you've spent your 2 years and many hours. At the end of the day, the goal is to get your application allowed, right? And then that's the end of the process with you, your attorney, and the USPTO, is that you've cleared up all of those rejections. The examiner has no more issues. You're happy. The attorney's happy. The PTO is happy, and it ends with what we call a notice of allowance, and that gets you the actual issued patent in your name, sent to your address. It's got a stamp and a ribbon on it and everything. And at that point, it is a legally enforceable patent, and that's really the end of that process. So just a couple takeaways. Your involvement is key throughout the process, right? It's your invention. It's and you need to be the one that's again, diligently working with your attorney to make sure that they are really looking out for you and your best interests. And again, you always have the ability to pick up the phone and call your examiner or schedule a conversation with them if you feel that the process is getting stuck. So I'm gonna end here with a resources piece, and then we'll open it up to Q&A. So I'll just take 5 minutes highlighting some resources that are available to help you navigate that process. I know that was a lot we covered, and don't expect people to really absorb all of it at this point. So we'd like to end with some resources that are available. We do have regional offices across the country. I'm assuming most folks are from the LA area, but we do like to highlight that no matter where you are in the country, there's a local office available for you. And we do offer, like I said, a lot of programming, a lot of how-tos at each step of the process, from, like I said, the patent search program is something that's been very popular and really helps people get started on the process. So you know, a lot of good free programming is available through the regional offices, as well as headquarters. We have a number of hotlines that you can call. You know, we have a website, USPTO.gov, but it can be challenging to navigate sometimes if you're not sure what you're looking at. And sometimes you just want to pick up the phone and talk to someone and say, hey, where can I find this form, or how, how do I, go about, doing X, Y, Z. So we maintain this hotline from 8:30 a.m. to 5 o'clock Pacific. You can pick up the phone and talk to someone who has worked in the patent office on average for over 15 years. It's not just a helpline of novices. The Inventor Assistance Center is a helpline of patent professionals and people that have worked in the field for years, that can help guide you, either if something as simple as finding a form that you need, to broader advice as well. Okay, so the pro bono program. So this is where we can actually connect you with a registered patent attorney, again, at low or no cost, to help you prepare your patent application and file your patent application. So we have a nationwide network that the USPTO partners with regional regional attorney groups. So in California, it's through the California Lawyers for the Arts, is the regional group that we partner with, where you're ready to file for a patent and you want to explore if you can work with an attorney at low or no cost. This is the way to go. So USPTO.gov /pro bono patents. And there's a slide at the end that has links to all of these. And again, we'll send you all of this information. But that's where you start. That will take you to your local resource, again, through the California Lawyers for the Arts program. That's where you register. They make you take a simple class that walks you through some patent basics, just to make sure that you do have an invention. And then once you go through that program, like I said, they will, and you meet the criteria, they will partner you with an attorney in your region, who will be working on your behalf, who will prepare the application for you, who will file the application for you, and who will have your back during those negotiations with your patent examiner. So again, it's California Lawyers for the Arts, in our state. And if you want to take a look at the nationwide network, or get a direct link to that, that's the USPTO.gov pro bono patents, is the resource there. And this just kind of shows you the nationwide network of what groups cover what states. And this is available all 50 states, and it doesn't show Puerto Rico there, but Puerto Rico is covered as well, in this program. If you're traveling out of state, or you want to share it with business partners or folks across the country, you can see, no matter where you are, there's a program that has you covered. In addition to that, I'll just briefly mention we also offer a law school clinic certification program. Same idea, as the pro bono program, except that this partners you with a law school student. Maybe various reasons you want to pursue that or not pursue that. It's ultimately a business decision for you all. But I will say the law school clinic program is open to, in many cases, trademark applications as well as patent applications. So, that may be something to keep in mind as you're looking at trademark applications as well. And of course, last but not least, we want to highlight our patent and trademark resource centers, really just a network of academic, state, and public libraries across the country that often do their own educational programming on patents and trademarks, or kind of rebroadcast and recirculate programs from the regional offices. And can help you, either kind of the boots on the ground in your backyard that can help you with doing some of the patent searches and with doing some of the filing preparation and just getting you access to resources in your area. And we'll send out a list to those local to your area. So and I think this is where I'm going to stop. These are some of the links that we talked about. Again, the pro se assistance programs, the fee discounts for the micro entity, and just some general guides that you can take a look at that talk about a lot of this information. So,
All right.
So with that,
oh, go ahead. Sorry.
No, I was just going to say, no, I covered a lot, and it's a dense presentation. So I thank you all for sticking with us, and we'll open it up to questions at this point for the next.
These
10
are
or
the
so
brave
minutes.
ones. They stuck in for the resources after you said 15 to 30,000, and some people jumped off. So y'all are brave. You stayed on to get more information. So appreciate that. We do have a quick poll that we wanted to share. So Briagini is going to bring that up, and there it is here. So first one, please answer this question. Okay, go ahead. And Steve, you can go ahead and
okay, I'm just looking at some of the chat here as well.
yeah. Okay, so we can end the poll here. And let's share. Oops, sorry. And let's share.
All right. All right, looks good.
So the answer is how many years?
The answer is 20 years. I voted in the poll as well, so it's a little bit skewed, but it looks like people did remember that. So good job.
Yep, and there was one question here about 50 years. So somebody had mentioned, where did that 50 years come from? And did that ever apply to patents? So that was one of the.
No, they might have been thinking. I know copyrights. The copyright term has changed over time. I think it's somewhere closer to 70 years right now. But the patent term was never that extensive. And in the past it was tied to when the patent was allowed, and it was 17 years back then. But in today's world, it's 20 years from the date of filing. So maybe they were thinking on copyright there.
All right, and I think we had one more poll. So Briagini, feel free to run that one. Or I think we have 2 or 3. Okay, so you guys please answer this question. Okay, the answers are coming in. 5 more seconds. Put your answers in. All right. Thank you, guys. And the answer is true.
True. Right. Remember, never pay more than you have to when you're dealing with the USPTO, and there's more likely than not, there's going to be a discount available the smaller you are as an entity.
Great. All right. And Briogeny, I think there's one more. So go ahead and launch that one. Question: once you file a provisional patent application, you have how much time to file your non-provisional patent application if you would like to claim the provisional patent application filing date? All right. You guys are putting your answers in. 10 seconds. All right. 3 seconds. All right. And the answer is, Steve?
12 months. Looks good. Looks good. Especially because I didn't directly even cover that. I kind of hinted at the importance of the 1 year grace period, but that's 12 months there. So excellent job. So people were paying attention here. So glad to
Great.
see it.
And that was Robin's question as well. So that was perfect. All right. And Briogeny, I think there's one more.
That was all of them.
Oh, that was it. Okay. All right. So actually, some of the questions were answered just with that poll, guys. So thank you for that. All right. So, question from Cy: if you replace the Statue of Liberty's torch with a sword, is it a different design patent? You have a design?
More likely than not, there's going to be something that you're able to protect there. But something to keep in mind, in that example, you all that your new design patent is going to be able to protect is that sword piece as well. So you're probably not going to be able to protect the actual base of the statue and the flowing robe and the crown and all of that, because that's already covered by somebody else's. So it's just going to be that which you have changed that you're going to be able to protect. So what does that mean in practice? Well, maybe you take your sword design and license it to whoever owns that original Statue of Liberty. So you'll have that one piece, but you're likely going to need permission from the owner of the rest of that design in order for you to start manufacturing something in that likeness.
Okay. All right. And do you suggest getting both utility and design patents for a product? And then Candlin is asking, do you do it for a single product? Can you get both for a single product? So they're related.
Yep, you certainly can get both for a single product. And it really comes down to, what is valuable about your product and what is distinctive about your product. If the way it looks, and if you're, if what's crucial to your sales is, the first 3 seconds of a consumer looking at your product and, ooh, there's something visually distinctive there, and that's where the purchasing decision occurs, then that tells me that design is critical, and a design patent may be really important to that product. On the other hand, if all the products in your field kind of look the same or close enough, and what the product does and how it performs better than a competitor's product, then we're talking about the function, right? What it does. And that is something where the utility patent may be more effective at protecting.
Okay. And then at what point, Jian Han asked, at what point does an invention become too much for a single patent?
Yeah, that's a real good idea there. And I didn't cover it, but there's a basic principle in the patent system where you get one patent per invention, right? So if you have an invention and you realize after this is actually maybe 3 or 4 different interesting ideas, and each of those 3 or 4 different ideas haven't been done before, or they're really kind of distinct and can be used across different products. You may have 3 or 4 separate applications that you can file there. So that's something that your patent examiner is gonna recognize right away. If you file an application and it really contains, 5 separate inventions, that's something where your patent examiner is going to give you the opportunity to split those up into 5 different applications. So that's kind of baked into the system, is that there's always going to be one invention per one patent.
Okay. And then someone asked about, I know you had mentioned the different patent corporations that might help you. Someone asked about LegalZoom, and I think that's just a resource, but not necessarily a patent resource. Can you speak to something like that?
Yeah, I guess the way I'll phrase it is that I'll be wary of anyone that guarantees that they'll be able to get you a patent, because they're not wrong. They will be able to get you a patent. It will be a worthless patent, but it will be a patent, right? So they are not wrong. They are not lying. They are not defrauding anyone when they say they can get you a patent. But again, it will not be, more likely than not, it will be a patent that's so narrow, right, that just covers just a small patch of grass in the backyard, right, that it's not going to be worth even the fees that you pay to the patent office, the $455 that you pay. It's not going to be, you're not going to be, what you're protecting is going to be so narrowly defined that it's not going to be valuable to you. So that's why we encourage, working with a registered patent attorney, who's going to be able to understand your business needs and understand how to translate those business needs into a legal document that protects what's valuable to you. And you don't often get that level of expertise when you're dealing with people through these invention submission corporations or other people that promise for $100 or $500 will get you a patent guaranteed, right? So again, I can't tell you how to spend your money. I can just say buyer beware when it comes to those types of corporations.
Thank you. And then a question here from Cy. We're going to take this, you guys. I have to share just a couple of pieces of information, and then if Steve is available for another 5 minutes, we'll try to finish up the questions here. All right. So how do you do a Google patent search to capture not just like pillow, but also sleep aiding apparatus?
Fantastic question there. And if you've ever spent a small amount of time actually reading through a patent document, you can be forgiven if it doesn't read like English to you, because they are dense and they are legal documents. And you can spend 15 pages reading an application on a pillow and never see the word pillow, because it's described, as a three-dimensional rectangular, apparatus. Lawyers have, have a talent for describing things in ways that will give you, again, that the maximum amount of protection for your invention. So the only answer there is you really have to do your homework, and you really have to spend some time with patent documents in your particular field of endeavor. And the good news there is that, and I'm going to jump to a different slide here. I think this shows it. Yeah, every single patent document that you see is going to have, this classification information, all these numbers that you see here. This is US classification, international classification. If you don't know where to start, that's a good place to start, because everything that qualifies as a chair is going to fit into one of these categories. So even if you don't have all of the clever lawyer's terminology at your fingertips, What you do have is a classification where everything that's a chair goes into this classification category. And I apologize, we don't have time to really dive deeply into that here. But again, if you look at some of the upcoming training that our office offers, and we'll share that with Colette for your reference, that's part of our patent search basics class that we offer, is how to combine, traditional Google keyword searching with the power of classification searching, so that you're really capturing all of those clever attorney tricks to where they don't. I'm just looking at this, chair abstract, a leaf spring supported free-floating rocker undercarriage for a swivel chair. And how many of you would have used those words to look for a chair, at least initially? So so that's where the classification piece comes in.
All right. And I would just wanted to share briefly, I saw someone put in the chat here about ask about trademarks. So we are going to be covering trademarks next week. This is our 3 of 3 series. So we encourage you guys to come back. We know not everyone will do a patent, but many of you might do a trademark. And so we definitely want you to participate. How do you register? How much will it cost? How soon? And what you should know now versus later. So we ask you to come back next week for that particular one. And then we do have all of these other workshops and things for those that may be new to us, including disaster loan funding. So we're doing a PPP and EIDL, a lot of good information, PPP forgiveness. For those that might still be in the process of thinking about launch your business, that is tomorrow. Marketing during uncertainty, certification for those of you that are typically existing, need certification, city, state, business planning, trademarks basics, as we mentioned, and then new client orientation. And we do have a restaurant academy. And so we have several events coming up in the restaurant academy that we want you to apprise yourself of. And then if we have a moment, I will show a video if anybody is still on, but I wanted, Steve, do you have about 5 more minutes for questions?
Sure, I'm happy to stick around.
Okay, so before you guys all go, I wanted to just thank Steve and Julie Mason as well. Steve is our presenter for today. Julie has been helping us to get these 3 workshops together for you. And we're so happy that they trusted us to be able to get people in to be able to see this great information for the small businesses. So we are so grateful for them. And Briogeny has been coordinating this behind the scenes. So we really appreciate her on our team making all of this happen. So I'm going to go back. We're going to try to get a couple of more questions in, and then we'll call it a day. But we hope to see you guys next week for trademarks. Please tell a friend. It's an area that trips up a lot of people. And so let's see. Okay. I see somebody's heart jumped off when you said 15 to 30 grand. That woke people up, I think. Okay, so let me ask this one question. Does a product need to be federally legal to be eligible for a patent as opposed to only being state legal? I have a feeling that might have to do with it could be a variety of areas, but marijuana in the state, might.
Yeah, no, I'm thinking back to, when the Farm Bill passed, what was it, end of 2018, and that kind of opened the floodgates there for a lot. Particularly, it's been challenging in the federal trademark realm. Around a lot of so, in CBD in particular has been an area where a lot of it's legal at the state level, and then there are still there's a level of federal scrutiny that comes in there, and that's something that we are actively working through. There are those that have federal trademarks on CBD related products. Because of the Farm Bill and because of how that kind of opened that up for for some interstate commerce there. But other than that, yeah, there are not all that many federal prohibitions on what can or can't be invented unless something is like the synthetic equivalent of a drug that's that's currently illegal at the federal level. That would likely be challenging to get a patent on.
Okay. All right. And then there was one here. Yeah, the second, if you needed to talk to a second patent lawyer to be eligible, could they use one of the resources that you have provided there to find a second one?
Sure. Yeah, there's you have the ability to shop around for someone that's right for you. So like I said, most all conversations are going to have that attorney-client privilege that you have when you're talking with an attorney and considering representation. So, a good way for the attorney to lose their job is to then take your idea and go file, a patent application on it. So that's a challenge.
Oh, right. And then someone asked, Tim Jones says, I cannot draw. I mean, really cannot draw. What options are there for somebody to help provide illustrations?
Sure, and most people who file patent applications work with a professional contractor who specializes in those types of technical drawings. So the reality of the process is you put together some hand-drawn notes, turn it over to a professional, what we call a drafter, and they'll draft kind of patent appropriate drawings for you.
Did not know about the drafter. Thank you. And then Charles is asking here, why don't you mention patent agents? What's a patent agent?
That's a good point too. Yeah. So patent agents are those who have a technical background. They've successfully passed the patent bar examination. So they're recognized by the federal government as being able to represent people in patent prosecution, but they are not attorneys. So what they can do is assist you with preparing your patent application, filing it for you, and working with the patent examiner. But they're not able to assist on, say, once you get your patent issued, if you need to sue somebody in federal court, or if you're looking at infringement, you think somebody is copying your idea and you want them to stop. They are not able to assist you with basically much of what happens after you obtain the patent. So they help you on the front end, and they can often do so for lower cost than what an actual patent attorney would charge. So that's a good option as well.
Okay. And I saw there was a question here to provide the difference between the patent and trademark. I wanted to patent versus trademark versus trade secrets. That was covered on last week's presentation. So we will, you can get the video for that, and we will set up so that you guys can have access to all three at the conclusion of next week, after the conclusion of next week. But that was reviewed last week. So you guys, I think that is it for now. I appreciate your comments. You guys, all of these resources are available to help you. And so use the resources that you have. And we thank Steve again for really great information. I didn't know as much about patents, even after being a patent holder, but that, not from a small business perspective. So you guys use all this great information to protect your businesses and figure out how it's going to help you do business and to stay sustainable, because that's really the whole point. And so how can you stay in business? That's the whole goal. So thank you guys. Steve, thank you so much again. Everyone have a wonderful day. Remember, SBDC Day is tomorrow. And there are a lot of different presentations going on, but feel free to do a hashtag SBDC Day and do a little video or something. That would be great for PCR SBDC or any of the SBDCs that you use. We appreciate it. We actually have a video hug. If anyone would like to participate, feel free to send us a info at our info box, info@pcrsbdc.org. With that, thank you all so much. And we look for the video. We do have one video already, and we'll be sending that out to everybody this year. So you guys have a wonderful day. Thanks again to the USPTO for partnering with the SBDC. We so appreciate you guys. Have a wonderful day, everybody. Thanks for joining.
All right. Thank you, everyone.
All right. Thank you.